There is a deep paradox at the core of agency law. One person physically negotiates the terms, signs the contracts, and executes the transaction, yet a completely different person is legally bound by the result. The boundary protecting the acting representative is found in Chapter 2, Title X of the new Civil Code. This legal framework forms a protective veil, shielding the agent from the personal financial ruin that would otherwise accompany massive corporate liabilities. To understand exactly how and why this protection fails, we have to conduct a forensic, article-by-article audit of Articles 1897 through 1909. For bar examinees and corporate practitioners alike, mastering these mechanics is entirely practical. This is the exact legal algorithm courts use to determine who absorbs the fallout when a multi-million peso deal collapses. Under Article 1897, the doctrine of representative relation establishes a baseline of absolute immunity. As long as an agent acts within the scope of their granted authority, they are merely an extension of the principal and incur no personal liability. But that immunity dissolves under strict conditions, easily remembered with the mnemonic EEN. The agent becomes personally liable if they expressly bind themselves to the contract, or if they exceed their authority with no sufficient notice given to the third party. The Supreme Court demonstrated this in National Power v. Nyamarco. An agent openly defied the principal's instructions not to proceed with a massive industrial sale. Because the agent acted without authority and failed to notify the buyer of those internal restrictions, the agent absorbed the liability for the contract directly. Examiners set a trap here by introducing a bankrupt principle. They suggest the third party can sue the authorized agent to recover their losses. The law blocks this entirely. An authorized agent's immunity remains intact regardless of the principal's insolvency. Article 1898 shifts the scenario to mutual bad faith. Here, the agent exceeds their authority, but the third party is fully aware of those limits. This creates the EAV formula. The agent exceeds authority plus third-party awareness equals a void contract. The principal is protected from the unauthorized act. Knowing they dealt with a rogue agent, the third party cannot sue the agent for breach. The only exception is if the agent specifically promised to secure the principal's ratification later and failed. Article 1899 presents the inverse problem. An agent acts in strict accordance with their orders, but the resulting transaction is a disaster. The principal attempts to void the deal by claiming their agent was ignorant of market conditions or product defects. The law applies the OOB rule. Obeys orders equals binds principal. If the principal dictated the specific actions, they cannot use the agent's ignorance as a shield. The fault lies entirely in the principal's poor instructions. The veil of agency exists strictly to protect the obedient proxy and the innocent principal. Any deviation into personal ambition, or any attempt by the principal to dodge the consequences of their own direct orders, shatters that protection. Under Article 1900 and the doctrine of apparent authority, the focus shifts to protecting innocent third parties who rely on the agency relationship. Under the WOS rule, written overrides secret. A written special power of attorney binds the principal, even if the agent violated a secret text message. The third party's contract remains perfectly valid. The principal's only remedy is suing their own agent for damages. This leads directly into Article 1901. Consider a scenario where an agent completely exceeds their powers, but the principal looks at the unauthorized deal and decides they actually want it. This invokes the RCD rule, ratification cures defect. The principal's acceptance travels back in time, validating the unauthorized contract as if authorized from day one. To prevent disputes, Article 1902 grants third parties the absolute right to demand the physical presentation of the written power of attorney before signing anything. The SIN rule applies here. Secret instructions never prejudice a third party. The sole exception is if the third party had actual knowledge of those secret limits. If they know about the restriction, their good faith is destroyed and they are bound by the limitation. The Supreme Court enforced this logic in Commissioner of Public Highways v. San Diego. The state tried escaping a compromise, claiming opposing counsel lacked authority. The court ruled that an agent's lack of authority can be questioned exclusively by their own principal. Opposing parties cannot use it as escape hatches. In commercial transactions, objective documentation reliably defeats subjective intent. Every actor is forced to rely strictly on what is explicitly written and officially presented. Article 1903 isolates the commission agent, or factor. To avoid paying out of pocket for inventory that was broken before it arrived, they must provide a written statement of damage immediately upon receipt. A common examination pitfall tests the format of this protest. A commission agent complaining verbally to the delivery driver is legally meaningless. Without a written protest, the law presumes the goods were received in perfect condition. Under Article 1904, we find the SKC rule. If an agent receives goods of the same kind from different owners, they face a strict statutory duty to use countermarks. Identical fungible goods must be physically tagged to prevent illegal commingling and accounting chaos. The law dictates that physical possession creates a presumption of perfection. The agent must actively document flaws and label every unit to survive liability. Moving to Article 1905, the commission agent faces an absolute prohibition against selling on credit without the principal's consent. This is the NCC rule. No consent equals cash demanded. If the agent violates this and executes an installment sale anyway, the principal is granted a powerful remedy. They can immediately demand the entire payment in cash directly from the agent. The offset to this harsh penalty is that while the agent absorbs the entirety of the collection risk, they are legally entitled to keep any extra interest or benefit the buyer eventually pays over time. Article 1906 shows that even when an agent is explicitly authorized to sell on credit, they face a mandatory reporting duty. The INC rule requires the agent to inform the principal of the buyer's names. If the agent hides or delays sending this list, the law imposes a punitive legal fiction to prevent fraud. Insofar as the principal is concerned, the transaction is immediately deemed a cash sale. Under Article 1907, an agent can opt into a different tier of liability by accepting a guarantee commission, making them a del creditor agent. Acting as a surety, the agent absorbs the total collection risk. If the buyer defaults, the agent must pay the principal from their own funds. Finally, Article 1908 details the FCD rule for ordinary commission agents. Failure to collect equals damages. They have a strict duty to collect credits precisely when they become due and demandable. Sitting on a due debt makes the agent liable for the loss. To escape paying damages, the agent must conclusively prove they exercised absolute due diligence, like sending demand letters or filing collection lawsuits. Financial agency requires relentless precision. Hiding a buyer's name or delaying a collection automatically converts the agent from a protected representative into a primary debtor. Article 1909 establishes the overarching standard for all agents, the fiduciary doctrine of diligence. As fiduciaries, agents answer for both intentional fraud and negligence. Courts judge negligence based on compensation. A paid agent faces a rigorous standard, while a gratuitous, unpaid agent receives leniency for mistakes. But beware the examination trap. Working for free mitigates negligence, but it never, ever mitigates liability for intentional fraud. The law may show leniency for a free agent's clumsy mistake, but it will ruthlessly punish active deceit. Articles 1897 through 1909 function together as an algorithmically precise balancing act, distributing risk across three distinct parties. The principal wields immense power to multiply their reach through proxies, but they are checked by their absolute inability to escape the written commitments their agents make on their behalf. The third party is heavily protected by their good faith reliance on written instruments, but they instantly lose that legal shield the moment they collude with a rogue agent or learn of secret limitations. The agent operates inside a fragile veil, deflecting external liabilities perfectly, but it shatters violently the moment the agent's silhouette reaches outside its explicit bounds. Do not just memorize the text of the civil code. Visualize the broken veils, the secret instructions, and the ticking clocks of collection. Master the forensic mechanics of these liabilities, and you master Title X.